point, the fact that the trial judge in the Japa case is also on the list. Justice Efia Sewa, you know, she's a fantastic judge. Of course, we have this being human, it cannot be all perfect. But today I'm not talking about those issues. So for this purpose, fantastic. But once it's come out that Japa says in his tape that Attorney General says that things have been arranged. Things have been arranged. Hey, and in Ghana here, the Attorney General is telling you that things have been arranged in a trial. Naturally, you would think about communication with the judge, etc. We can't shy away from this. Let's be very open, right? Otherwise, our democracy will not grow. So when I saw the list, I said, hey, then is that part of the things have been arranged? There will be suspicions, and I'm not the only one. Even in the Ghana Bar Association, the Supreme Court itself recognizes it. You see Achugba talking about it, that people have always been skeptical, etc. Not once, not twice, more than 3 times. He quotes from Justice Dr. Dateba's book. Let me read a little bit about it. He says, listen, this long-standing skepticism of the independence of the judiciary and now the Supreme Court in particular led to the issuance of the following practice direction, blah, blah. So they've always been suspicious. So at some point in time, Justice Uredu said all of them should sit, all the Supreme Court justices should sit on constitutional cases, or minimum of 7. Then later, another, was it Wood, who came and said then at least 9. We are not able to do 9. We do 7. I think they will do 1. Then you go on. So Atuba, his opinion is laced with so many quotations showing our history, the way Kwame Nkrumah made the judiciary very pliant, right, etc. So they trace our history and you see that citizens have never trusted the courts. That's it. It didn't start today. Yes, they will quote and quote and quote, right? Look, you go to page 885. This skepticism, as noted at pages 48, 49 of Dr. Dateban's formidable book, Reflections on the Supreme Court of Ghana, blah, blah, blah. Then he go on. So you see that Dateba also mentions, states the point. So what we're saying is that we're developing the point about Justice Asaribuchi being on the list. So when I saw her name, I said, yeah, this is...
Especially when the trial is ongoing.
Exactly. I said, this why it will just feed into the suspicions. And you follow debates and you see people saying it all over that, we knew it. You see, it's unfortunate. So maybe all of this should have informed the manner in which this was done. That, look, let's shelve it for now. You remember President Obama in 2016 when he was leaving, he wanted to appoint the current Attorney General, Mary Garland, to the Supreme Court. The Republicans told him that, no, this is an election year. It's too late. It's too late. So Garland didn't make it. So, I mean, please, the time is too late. At least, but you know that 2 have been approved.
Justice, 2 out of the 5.
No. They are not there. They are an additional. Frimpong. It's Frimpong on their 5.
No.
Frimpong, Justice Dr. Frimpong, and then
he's not on the 5.
Benasco Issa. So I understand 2 have been approved. So they will soon be. They will go through. They are not on this list.
This is not.
Yeah. So the Daily Post story I read. I understand the Judicial Council has made a recommendation for 2 to go through. So we are now. Is these 5 that have been shut down? It's an election year. Barely 4 or 5 months to an election. Notwithstanding that the justices, the nominees are good, etc. But I think the timing is bad. Let's deal with the election first, and then after that, we can come back. And then, as I mentioned, if we are going beyond 40, let's have a full debate about it. So is it that we're going to restructure the Supreme Court and have various divisions like this, a constitutional court, this is not? So there must be a debate if you are going beyond the 40.
So this has nothing to do with the competence or otherwise of these 5 persons. It's a lot more about the procedure.
Exactly. And it's good you are asking so that I will repeat. We don't want to, these are fine justices. As for Cheba, you could see that, yes, very, very independent. The rest of them, Justice Homia, these are people who have appeared before. So you can't fault them on competence. So this debate is not about competence at all. We are talking about the timing. We don't want midnight judges. You remember, even just 2 weeks ago, we were talking about the case of Marbury versus Madison, midnight judges, where the outgoing president the night before was signing the appointment letters of some judges, and then he had to lose. And so John Adams, when John Adams was leaving, and then President Jefferson, Thomas Jefferson came in. Then Jefferson didn't want to let them have their appointment letters, and then they went to the Supreme Court and all that, right? So that's where we got the phrase midnight judges. That's a judge who is appointed very close to the time of exit of a president. No, we don't want it. I think let's go on and then finish, and we can always come back to the appointments later on after a national debate. After a national discussion, that now we are lifting the upper threshold from 14 to a greater number. And let me also quickly mention, we also follow social media and also even in some legal circles where there's the comparison that the US, over 200 million people, they have just 9 Supreme Court justices and the rest.
Yes.
It's a lot more complex. Let's just briefly mention that in the US, each state has its own
Supreme Court.
Yes, Supreme Court.
State
Each state.
Supreme Court.
So over 50 states, right? All of them, they have state Supreme Court. So you go from the county courts, etc., up to the state Supreme Court. And then, even possibly after the state Supreme Court, some of the cases now go to the US Supreme Court, etc. So it's complex. So please don't just do the 9 against 20 that we want to have in Ghana. It's a lot more complex. Let's leave that. As I've said, for me, let's do a national debate, because the African peer review mechanism tend to, as I said, we've said it in the past. We promised them that we conventionally, we've never gone beyond 14. So if now we want to break that convention, breaking the 14. So if you want to break the 14, hey, the 14 is interesting. Just like in the UK, the conservatives were trying to break the 14. They couldn't break it.
Anyway, the 14-year rule ended in a very disastrous defeat.
Landslide.
And anyway, but this is what the Chief Justice said. And I like the fact that, Counsel, you lay out a number of issues. Yes, competence is not an issue. The need for more justices at the Supreme Court is not an issue. It's a very legitimate demand that we have because of the number of cases at the Supreme Court as we speak. But then again, it is not because of these legitimate issues that we will do away with proper procedure and how the things need to be done in the right way, so as to even do away with the suspicions and all of this, that even now, as you've indicated, this has fed into some suspicion, if it is, that not just the NDC had, but some other persons as well, especially because of even the names in there. Justice Efia Saribotwe, fantastic judge, as you've indicated, but then again, with what is happening now, circumstances would create the legitimacy for any suspicion about why her name is there. And especially if this case turns out in a certain way, this ambulance trial, because of everything that's happened from May 23 to date, with the revelation of Richard Jakba and so on, and this audio and how the Attorney General is involved and all of that. And to the extent that the AG is even on this judicial council that will have to approve these names. It's but let's take a listen to this.
Especially, you haven't added the fact that the judge advised the Attorney General to stay away from the trial. And yet now the Attorney General is back in the saddle, continue with cross-examination. Then you are like,
So it's like murky. So, but let's take a listen to the Chief Justice on this.
There are several cases pending, right? That's why we need more Supreme Court judges. The discussion must be placed in context. There are several cases pending, right? That's why we need more Supreme Court judges. The discussion must be placed in context.
That's why we've done the best we can to place this discussion in context. Nana? Yes. You're not a lawyer, but then again, you go to court.
Yes.
So
I've gone to court a lot.
So certainly, these are issues that matters, obviously. Yes.
Yes. I've listened to the lawyers, so I think I have a fair sense of what's going on. Now, if it is the case that the law requires that it is the Judicial Council that makes the recommendation, then for me, that is the starting point, really. That clearly would show that our Chief Justice has actually basically sidestepped the law, if you like, has not done the right thing as far as the law is concerned. Now, sometimes I like quoting aspects of the Bible in some of these matters. The Bible will tell you that God is supreme. He's created everything. And He's created the law for the universe, His word. But He Himself is ruled by His law. God is not above His own laws. No.
It's divine laws.
Yes. So the Chief Justice, in terms of the authority to interpret our laws, of course, sits at the apex with her court now. But even that Supreme Court is still under the law.
Okay.
I mean, from a layman's point of view, I'm sure the lawyers can correct me.
Yeah, that's correct.
Yeah. So really, if that is the case, then it means that in terms of the Constitution and proper law, then the Chief Justice has not acted properly. You know, and I'm happy Lawyer Kpebu referred to a lot of the comments some of the justices, and especially one of the former Chief Justices, Atukuba, has made to the lack of confidence that citizens may have in such critical and sensitive institutions of state as the Supreme Court. Now, a lot of these sentiments of lack of confidence are quite properly grounded in our sense. If I say our, I mean those of us who are laymen, our sense of the integrity of these institutions and the way they present themselves. Now, if in the Constitution of the Supreme Court itself there are doubts, there are issues of credibility, there are issues of non-legality and unconstitutionality, then we are heading into serious problems. I believe that even outside of the law and the Constitution, it is also coming out clear that just the ethical factors around the whole thing doesn't make it look good. If you have what people see as a very highly political case, in the example of Honorable Atuforsen and the ambulance matter being on the front burner of public discussion, and the judge at the center of it, who, as far as the NDC and some political opponents see as being used, the court is being used to persecute a political opponent. And now this judge happens to be one of the nominees. That one alone is enough to spoil the whole discussion and to send a signal that no, this could be up to some political gimmicks, which may not necessarily be the case. It may not be the case. But now that there is a whole lot of confusion and lack of trust and lack of confidence as far as the politics of that case is concerned, if you name this particular judge as part of it, it makes it even more problematic. So I would say that aside of the law, I think we should try and avoid the appearance of undue political influence. And I'm choosing my words very carefully. The appearance of. Because you see, as for us laymen, it might not be that there is political influence, But as soon as there is something that gives us that impression,
Appears to you.
it appeared to me that there is political influence undue. I am not saying that you can totally avoid political influence. In any case, if constitutionally the president has the authority to appoint, already it's a political process. It is something, even though it's constitutional, the president is vested with the political power of the state, the whole state. So there is politics out there. But where it begins to appear that the influence of a certain political bias is unduly being brought to bear on this process, we will forget about the substance. We will put aside the real issues and just focus on the peripherals. You know, but in any case, even in this case, there is a major case to be made for the substance in terms of law. So that is bad enough. Now, secondly, you are looking at a situation where people feel that there is some political underhand dealing. It just doesn't go to help the credibility issue of the institutions of state who require, by necessity, they require to have that credibility. People need to have confidence in, say, the police. People need to have confidence in the courts. People need to have confidence in the Supreme Court of Ghana. So if there is anything that is done to take away from that credibility and create confidence issues, I think it's a very major problem for our democracy and the institutions of democracy. Now, as for the excuse that the workload of the Supreme Court is so heavy that they need more judges,
I don't think that's an excuse. I think it's
no. Listen to me. Why I say it's an excuse? Because there are ways of going about it. My suggestion, I'm not a lawyer, but I spoke to a lawyer and he tried to explain to me before I got into the studio about this. That's why I call it excuse.
Okay.
Now, if we think just a little clearly about this matter, why should all land cases end up at the Supreme Court? Why should all business cases end up at the Supreme Court? Why should all chieftaincy cases end up at the Supreme Court? Why should all matrimonial cases end up at the Supreme Court? So simply put, I am saying, this is my layman. When I had a chat with the lawyer, I told him, I said, look, so why don't you create specialized courts who have finite authority over certain particular sectors of the law, so that, say, constitutional matters and others of a certain nature and magnitude will then be ceded to the Supreme Court. Okay. Now, every single land case has the potential to travel to the Supreme Court. Every marital case has the potential to travel to the Supreme Court. Every chieftaincy case has the potential to travel to the Supreme Court. But you want to let this court possess that weight, that authority, where it deals with cases that no other persons or no other courts would appear not to have the capacity to deal with. You know, I don't know how the technical people will look at this, but I think it is quite practical. When I tried to find out a little bit about the U.S. Supreme Court, it doesn't appear to me that almost every case will end up at the U.S. Supreme Court.
Yeah. They have a sieving process.
A process.
Yeah.
So I am saying that sieving,
yes, they sieve it,
yes,
to determine whether or not
it should go there.
Yeah.
So it's in there, it's received there, but there are a number of clerks. There are specialist lawyers.
So let us find a way. Let us find a way of making sure that, look, if a land case of a certain nature can be handled and concluded, and it doesn't even go beyond the appeals court, why don't we find a way of doing some of those things?